And due for the sake of due process, and I think
Sorry,
that's kind of what he.
that's a word salad. It's not making any soup.
Shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used. And the man speaking with a voice and
Okay,
a
so
sound
I'm going to
mind.
cut this off. What is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir.
you?
No, we're gonna focus our answers here. May I have appearances for the record, please? Mr.
Sure.
Nitz? Thornton, could you state your name for the record, please?
I am the I am Shoulders in here by way of executive office for Latavius State Authority, nonprofit organization.
Except that is Mr. Thornton announcing his appearance before the court. We are here this morning for a pre-exam conference. Mr. Anid, it is my understanding that Mr. Thornton has declined representation. However, Mr. Thornton, at every appearance, I need to remind you that you have a constitutional right to be represented by an attorney, and that if you can't afford an attorney, the court will provide one for you. I am particularly proud of the superb public defenders we have in this court. However, you may also retain any attorney you wish. You will get to choose the attorney. You would have to pay them. You have a constitutional right to represent yourself, but I have to warn you that if you proceed representing yourself, you would be held to the same standard as all attorneys who have gone to law school, passed the bar, and been admitted to practice. So the court really can't give you any breaks or help you at all. Is it your wish to represent yourself, sir?
Mr. Thornton is aware of the courtroom decorum and the standards and procedures that must be upheld by a person in representation of a party. And as again, Shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used, and to forgive me, and to uphold the proper standards. Mr. Thornton does not wish to get public counsel representation as I am a legal representation by special appearance through the executive office for Mr. Thornton and not the actual entity, Latavius State Thornton. Once again, on the record, it has not been declined that Latavius State Thornton is a nonprofit organization, which, yes, Your Honor, is a person, in fact. And the man speaking with a voice and a sound mind.
I'm going to cut this off. I don't want to mute you, but we have to move forward. We have an attorney standing by. That would be Mr. Foreman. Have you had an opportunity to speak with Mr. Thornton about any plea offer?
No, Your Honor, and I don't think I'll have any meaningful conversations with him based on what I see. I believe that it's not clear whether what he's doing is intentional or whether this may be a competency issue. But I'm prepared to proceed. I just don't know if we should. I have a concern for his competency, to be honest with you. If of course we had the same issue this time.
No, Mr. Thornton, one person at a time. And right now, Mr. Annette is speaking.
I mean, I guess I would inquire with whether he knows what a preliminary exam is, and if he understands, if we forward, if he's gonna know what to do. I mean, I believe I have to look at the court rules. I've never dealt with this issue, but I think having standby counsel would be something that would be needed to advise him. I'll look into all that, but I just don't know if he's gonna know what a preliminary exam is. I believe this may just be a competency issue. I don't know, Your Honor.
Okay, so actually that's a good question. So, Mr. Thornton, I'm going to ask you, what is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir.
you?
No, we're gonna focus our answers here. What is a preliminary exam?
Your Honor.
I'm going to give you one chance to answer. What is a preliminary exam?
A court proceeding.
Okay, and what happens? That's a good answer. What happens at that court proceeding?
at a preliminary examination court proceeding, the parties have the opportunity to present evidence, cross-examine each other, and determine whether whether evidence is admissible to go into to put continual proceedings, whether the court has jurisdictions. A plethora of matters may be brought up in a preliminary examination to see if the court has a valid standing, to see if there's anything, to see what may be addressed that's necessary as far as the parties that are at hand, not only to go about things in a one specific fashion.
Well, that's pretty that's a pretty good answer. However, at this point, given a review of
Your Honor,
history, the court is going to sua sponte suggest that a competency exam be ordered. Mr. Anid,
I
any
agree.
response?
I agree.
Okay, thank you. Mr.
Yeah.
Thornton, any response?
Mr. Thornton does not believe that a competency gram sua ponte is necessary and objects that as a preliminary exam is something that we can proceed to and we can address the matters and the situations that are necessary at that time. And for the sake of due process and the judicial precedence of due process, that a criminal or a competency test may delay that, and it could hinder not only Mr. Thornton, but the things that Mr. Thornton does as far as the community and his career and his family and his life and rights, and other people that may be affected by this matter, as well as the public. Because for the judicial precedence is that Mr. Thornton is innocent and not guilty.
So, Mr. Anid, are you going to prepare a proposed order or?
Your Honor, I think it's been a while since I've done. I believe if I'm not mistaken, it's the. I can if you want. Yes, I'll prepare an order.
All right. So at this time, Mr. Anid, comment on the preliminary exam?
Nope. I just say we just make the preliminary examination to be determined date. If anything, reset it for another PCC or review hearing for when we do come back with a competency opinion.
Okay. So, Mr. Thornton, you have two rights at play here. One is the preliminary exam that we just discussed, and the second is the right to have that within 21 days. So, the reason that you have a right to have that within 21 days is to prevent cases from dragging on endlessly. There are certain timelines that have to be met. However, the court can waive that 21 days if it finds good cause. And that would be, for instance, if one side had recently received discovery and was unable to proceed. Another good cause could be if someone was ill or hospitalized. There could be any number of good reasons. So I'm going to ask you, actually, Mr. Thornton, have you received any discovery in this matter?
I have not. Mr. Thornton has not received any instrument.
Okay, so all right, two things then. First, I find good cause to waive the 21-day rule, and we will get a date. No, sir, just a minute. Let me finish. You can't. You don't. No, I don't want to mute you, but I have to get through this. So, you have to have you have a constitutional right to have knowledge about your case, and if you haven't received any discovery, we can't go forward until you receive it. So, two things. First, I'm going to waive the 21-day rule. And just a minute, Mr. Sid. We're going to waive the 21-day rule, and we're going to set a date out in about a month. That'd be a placeholder date. At this point, because you are representing yourself, I'm going to allow you to converse with Mr. Anid, recognizing that you do not have discovery materials, so I do not expect this court to accept a plea bargain today. We're going to put you both in a breakout room, and when you're done, the court will be ready. Thank you. Okay, sound is back on at the jail, so we will go back on the record in the matter of People versus Latavius Rashad Thornton. This is case 25-0203-FY. Mr. Anid, prosecutor, and Mr. Thornton, representing himself, have met in a breakout room. So first, because the prosecutor has burden of proof, I'm going to ask Mr. Anid first, then Mr. Thornton, I'll ask you. So Mr. Anid, anything from the breakout room that you'd like to report?
Yes, I just want to make sure Mr. Thornton is there because I don't see him on here.
Oh, I see him. Do you,
Okay. Can you hear me? Okay. Yep. So we discussed. Yep. We discussed a little bit of as much as we could. I believe based on my discussions with him, I don't believe this is a competency issue. I believe this is more of the what Mr. Thornton kind of described earlier. So the plan, I think we both agreed on, is we're asking for another probable cause conference. I'm going to somehow figure out how to provide him discovery, the complaint, the information, all the charging documents that we have. We're going to come back. In the meantime, I'm going to do my due diligence to speak with our office to see how we're going to go forward with this. Because I know it's my understanding he wants to represent himself. That is his right. I believe based on the questions that you asked earlier, he answered them pretty fairly, Your Honor. I just want to make sure we got all ducks in order. I discussed a misdemeanor offer potentially with them, but also discussed that I encourage him to get a public defender. All these things I think we're going to discuss at the next probable cause conference. I think these are all appropriate matters so I can get my ducks in order. He can have discovery to know what he's looking at. And I believe at the next hearing, we will have a good understanding of what we're doing going forward.
Mr. Thornton, is that an accurate report?
It's pretty accurate, Your Honor. Just a few more points that we had discussed in that breakout room was also that it was in the discovery we would like to get subject matter in the appointment of the authorities that has been filed onto the record for these proceedings and how we came about to be into the court's jurisdiction for this matter in such fashion. And I think that's kind of what
that's a word salad. It's not making any soup. Can you make sense at all? Can you rephrase that for me? Mr. Thornton.
Okay. So just pretty much all in the discovery, we didn't want any documents that have been filed onto the case to be missing, and that's what I mean by not limited to the documents titles that he named. It include an inclusion of all documents filed with all titles under them.
And
okay.
I'll chime in
Mr.
here.
Ned.
And I think kind of what he may be talking about is, and I could be wrong, is the charging documents, what gives us the authority to proceed forward and how we're proceeding forward. And I explained you should wait until you discover it because I believe that's going to be the complaint, the information, and the other charging documents to see where we're at. I could be wrong, but once he receives those, we'll come back. We'll have all the ducks in order. I think that's a good resolution we both agreed on. And in the meantime, I'll do my due diligence to speak with our office to how we're going to go forward. I told Mr. Thornton, I'm the prosecutor. He understands what the prosecutor is. I'm not on his side, but I did advise I'm here to help get the situation resolved as fast as possible. And I think we both agree that if you find good cause to adjourn this for one more probable cause conference, I believe everything will be situated.
Mr. Thornton, anything further this morning?
Not at this time, Your Honor.
Just new dates, Your Honor. New dates. Our new probable cause.
Okay, so we had the dates, and that is 8:30 a.m., April 25th, for a probable cause conference, and 9 a.m., May 1st, for a preliminary exam.
Okay, so the next probable cause conference is about a month away. Does that sound right?
Yes.
Okay. All right.
So, Mr. Thornton, if at any time you change your mind, you can communicate with the court and or Mr. Anid about requesting counsel. At every hearing, I'm obligated to tell you your right about counsel and to determine the parameters of that. All right, so we will see you back at 8:30 a.m., April 25th. That is all.
Thank you, Your Honor.
Thank you.
Take care.
Thank you.
Take care, Mr. Amid.